You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. State attorneys general are the primary enforcers of privacy obligations across the United States. Their jurisdiction typically flows from broad consumer protection mandates, giving them authority to address privacy violations as unfair or deceptive acts. This role has expanded as personal data became central to commerce and daily life. Attorneys general position themselves as advocates for residents whose privacy may be compromised by poor data practices, opaque policies, or negligent security safeguards. Their broad remit allows them to bring actions under both general consumer protection statutes and specific privacy laws, creating a flexible enforcement posture. For businesses, this means that privacy obligations cannot be viewed narrowly. Almost any misleading or inadequate privacy practice can fall under the scope of Attorney General authority. Unfair and Deceptive Acts and Practices statutes, commonly referred to as UDAP laws, form the anchor of Attorney General privacy enforcement. These statutes are deliberately broad, prohibiting practices that mislead consumers or that create substantial and unavoidable harm. In the privacy context, this might include a company promising not to sell personal data but then monetizing it through affiliates, or failing to secure sensitive data despite representations of robust security. The flexibility of UDAP laws allows attorneys general to adapt enforcement to emerging technologies and practices, even before specific legislation is enacted. For organizations, aligning representations with actual practices is critical, as discrepancies are a ready target for UDAP enforcement. Attorneys general wield powerful investigatory tools to pursue privacy matters. Civil investigative demands, subpoenas, and other compulsory processes allow them to obtain documents, contracts, and technical records. They may demand testimony from executives or require the production of logs showing how personal data is collected and used. These powers give attorneys general leverage to uncover both intentional misconduct and negligent practices. Businesses facing such inquiries must respond with precision, ensuring that their records are complete and accurate. The investigatory phase often sets the stage for negotiations, as the scope of evidence collected influences both the posture of regulators and the options for resolution. Multi-state coalitions are a hallmark of privacy enforcement. Attorneys general frequently coordinate across jurisdictions to address large-scale practices affecting residents nationwide. For example, coalitions may form to pursue data broker practices, online advertising models, or social media privacy violations. Coordinated settlements allow states to share resources, harmonize remedies, and increase pressure on businesses to reform. For organizations, this means that a privacy issue identified in one state can quickly escalate into a national enforcement matter. The architecture of multi-state actions reinforces the reality that privacy compliance must be designed for scale, not piecemeal by jurisdiction. Resolutions often take the form of assurance of voluntary compliance agreements or consent judgments. These instruments allow businesses to settle without admitting wrongdoing while committing to specific remedial measures. Agreements may include ongoing monitoring, changes to privacy policies, or the appointment of independent assessors. They are enforceable in court, ensuring compliance is more than symbolic. For businesses, entering such agreements often means years of oversight and reporting obligations, reinforcing the long tail of enforcement. These mechanisms balance remediation with efficiency, resolving disputes without full litigation while still embedding accountability. Penalty frameworks vary by state but often include calculations based on the number of affected consumers, the duration of misconduct, and the intent behind violations. Cure periods may be offered, allowing businesses to fix problems before penalties are imposed, though not all states provide such grace. Injunctive relief is common, requiring companies to cease unlawful practices immediately. Penalties can range from thousands to millions of dollars, depending on the scale of the violation. This variability highlights the importance of early compliance, as waiting for enforcement not only increases costs, but also magnifies reputational harm. Some states have created specialty units within attorney general offices to address data privacy, cybersecurity, and technology matters. These units bring technical expertise, enabling more sophisticated investigations into algorithms, data flows, and security architectures. They also signal that privacy has become a distinct regulatory priority rather than a subset of consumer protection. For businesses, this specialization means that enforcement is informed by technical understanding, reducing the chance of dismissing issues as mere misunderstandings. Specialized units are more likely to demand detailed compliance programs and scrutinize advanced technologies such as artificial intelligence and biometrics. Data breach notification enforcement is one of the most common areas of attorney general activity. Every state has a breach law, and attorneys general review timeliness, completeness, and accuracy of notifications. Delays in disclosure or incomplete reporting are frequent targets for enforcement. For example, failing to inform consumers of a compromised Social Security number until months later may trigger substantial penalties. Breach enforcement highlights the importance of having incident response plans that integrate regulatory requirements, ensuring that organizations notify not only affected individuals, but also regulators in a timely manner. Transparency, misrepresentation, and adequacy of notices are core enforcement priorities. Regulators scrutinize whether privacy policies are clear, accurate, and aligned with actual practices. Vague or overly legalistic notices risk being labeled deceptive. For example, stating that personal information is collected for business purposes without explanation may not satisfy transparency obligations. Attorneys general emphasize that consumers must be able to understand how their data is collected, used, and shared. For organizations, this reinforces that privacy notices are not simply formalities, but compliance artifacts subject to enforcement. Children's and teen privacy are prominent in attorney general portfolios. Offices enforce both federal law, such as CCPA, and state-specific protections. They pay close attention to social media, gaming, and educational platforms that target or are accessible to minors. Missteps in consent mechanisms or failure to limit profiling can lead to significant actions. Teen privacy has become a particular focus as states examine how platforms use design features that encourage excessive sharing or engagement. Enforcement in this area demonstrates heightened sensitivity to vulnerable populations, signaling that practices involving youth require special care and scrutiny. Data broker oversight is emerging in states that require registries or impose obligations on companies that buy and sell large volumes of personal information. Attorneys general enforce these registries, ensuring that brokers disclose their practices and respect opt-out requests. Noncompliance can result in fines and reputational harm, particularly in states like California and Vermont with established broker registries. Oversight of brokers reflects broader concerns about the secondary market for personal information, which is often opaque to consumers. Regulators seek to bring transparency and accountability to these practices through direct enforcement. Cooperation with federal agencies is another feature of state attorney general activity. Privacy investigations often overlap with the Federal Trade Commission, the Department of Health and Human Services, or other federal regulators. Joint actions leverage complementary authorities, enhancing enforcement reach. For example, the FTC may focus on unfair practices while state attorneys general pursue deceptive representations under state law. Businesses must prepare for this overlap, recognizing that one investigation may invite scrutiny from multiple fronts. Parallel proceedings require careful coordination of responses and may increase both complexity and cost. Evidence development in privacy investigations draws on technical and contractual artifacts. Attorneys general review server logs, data maps, contracts with processors, and internal communications. These records provide insights into whether practices match policies and whether safeguards are adequate. Technical evidence, such as access logs, can demonstrate whether security measures failed or were ignored. For organizations, maintaining accurate records and aligning them with stated practices is essential. Poor documentation not only hampers defense, but can itself be viewed as a compliance failure. Even after settlements are reached, post-settlement monitoring plays a critical role. Regulators may require periodic reports, independent assessments, or certifications of compliance. These obligations extend the reach of enforcement long after initial violations are addressed. Independent assessors may review privacy programs annually, providing regulators with assurance that commitments are being honored. For businesses, this underscores that enforcement does not end with a signed settlement. It marks the beginning of ongoing oversight. Post-settlement monitoring reinforces accountability and ensures that reforms are not temporary fixes but lasting improvements. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The California Privacy Protection Agency represents a major evolution in state-level privacy enforcement. Created under the California Privacy Rights Act, the CPPA is the first U.S. agency dedicated exclusively to privacy regulation and oversight. Its governance structure includes a 5-member board appointed by state officials, combining expertise in privacy, consumer rights, and technology. The CPPA's independence allows it to issue rules, conduct investigations, and enforce compliance without relying solely on the Attorney General's office. For businesses, this means that California has a specialized body with the resources and mandate to scrutinize data practices at a granular level. The establishment of the CPPA signals that privacy is no longer an adjunct of consumer protection but a regulatory domain in its own right. The agency wields broad rulemaking authority, shaping requirements for privacy notices, opt-out mechanisms, automated decision-making, and consent. Through regulations, the CPPA can refine statutory obligations into detailed operational standards. For example, it can specify how opt-out links must be displayed, or what information must be included in privacy notices to make them meaningful. It can also develop rules governing algorithmic profiling, requiring businesses to provide explanations or opt-out options. This power to translate legislative intent into enforceable detail creates significant compliance demands. Businesses must follow not only statutory text but also CPPA regulations, which may evolve as technologies and practices change. Investigative powers enhance the CPPA's reach. The agency can issue subpoenas, compel sworn testimony, and conduct audits of company practices. Unlike complaint-driven enforcement, audits allow proactive review of organizations even without suspected violations. This shifts compliance from reactive to preventative, requiring businesses to maintain programs that can withstand scrutiny at any time. For example, a CPPA audit may examine whether privacy impact assessments were completed for high-risk processing or whether data retention policies align with statutory requirements. The breadth of these powers reflects a European-style oversight model, with regulators empowered to examine practices proactively rather than waiting for consumer complaints. The administrative enforcement process adds structure to CPPA actions. Investigations may begin with inquiries, progress to formal examination, and result in probable cause findings. If probable cause is established, the case may proceed to administrative hearings, where penalties or corrective orders are imposed. This process provides due process protections for businesses while still ensuring accountability. The CPPA's ability to manage its own enforcement procedures without relying exclusively on courts accelerates oversight and increases the certainty of consequences. For organizations, this means regulatory exposure is not hypothetical. It can materialize quickly through administrative channels. Penalties under CPPA authority are structured to reflect severity. Factors considered include the intent behind violations, the duration of misconduct, the number of consumers affected, and whether mitigation efforts were undertaken. Civil penalties can reach into the thousands per violation, and multipliers based on affected individuals can escalate costs dramatically. Businesses that demonstrate good faith, document compliance efforts, and respond quickly to identified issues may see reduced penalties. Conversely, ignoring obligations or attempting to obscure practices magnifies enforcement consequences. This penalty framework underscores the value of proactive compliance programs. The CPPA also clarifies roles for businesses, service providers, and contractors under California's framework. Regulations define what activities are permissible for service providers, how contractors must handle data, and when joint controller obligations arise. For example, service providers may only process data according to contractual instructions, and contractors must certify compliance with statutory duties. These clarifications reduce ambiguity but also increase accountability across the supply chain. Businesses must ensure that contracts and practices align with these definitions, as misclassification of relationships can trigger liability. One enforcement priority is honoring global privacy control signals. These browser-based tools allow consumers to automatically communicate opt-out preferences for data sales or targeted advertising. California requires businesses to treat these signals as valid opt-out requests, making technical compliance a regulatory obligation. Failure to implement systems that recognize GPC signals risks enforcement. This reflects a broader trend of embedding privacy into default technologies, reducing the burden on consumers to navigate complex opt-out mechanisms. For organizations, this requires technical integration and testing to ensure compliance. Dark patterns design choices that manipulate users into providing consent are another CPPA focus. Regulations prohibit practices that obscure, subvert, or coerce consumer choices. For example, burying opt-out links under multiple layers of menus or using confusing language like "don't decline" would violate consent standards. The CPPA emphasizes that consent must be informed, unambiguous, and free of manipulation. This pushes organizations to rethink interface design, prioritizing clarity and fairness. By targeting dark patterns, the agency addresses not just the letter of privacy rights, but also the user experience that enables or undermines them. Children's privacy remains a top priority. The CPPA enforces age-related consent standards and coordinates with California's Age-Appropriate Design Code. Businesses offering services likely to be accessed by children must configure default settings with privacy in mind, avoid profiling, and limit data collection. Enforcement in this area reflects growing societal concern about the digital experiences of minors. For businesses, compliance requires building safeguards into products from the outset rather than treating them as afterthoughts. The CPPA's oversight ensures that youth protections are not symbolic but actively enforced. Core privacy principles such as data minimization, purpose limitation, and retention policies are central to CPPA rulemaking. Businesses must collect only what is necessary, use it for specified purposes, and delete it when no longer needed. These obligations align California with international privacy norms while adapting them to U.S. contexts. Enforcement in this area targets organizations that accumulate data indefinitely or repurpose it without consent. For example, retaining customer data for years after account closure without justification could trigger scrutiny. Clear policies and defensible practices are essential for demonstrating compliance. Risk assessment obligations extend oversight into sensitive areas such as profiling and the processing of sensitive data categories. Businesses may be required to conduct and document risk assessments before engaging in high-risk practices. These assessments must weigh benefits against risks to consumer rights and consider mitigation measures. By mandating risk assessments, the CPPA encourages organizations to evaluate impacts before deploying technologies, embedding privacy into project planning. For businesses, this shifts compliance upstream, requiring diligence in design and deployment rather than reactive fixes. Coordination with the California Attorney General ensures that CPPA oversight does not operate in isolation. Both entities retain enforcement powers, and collaboration prevents duplication while leveraging complementary strengths. For example, the Attorney General may focus on broader consumer protection cases while the CPPA hones in on detailed privacy compliance. Businesses must prepare for oversight from both authorities, recognizing that cooperation enhances enforcement reach. This dual structure creates a robust regulatory environment where privacy obligations cannot be easily ignored. The CPPA also provides guidance, FAQs, and advisory publications to help businesses understand their obligations. These materials translate statutory and regulatory language into practical expectations, offering clarity on compliance pathways. Organizations should treat such guidance as authoritative, as failure to align with published expectations may increase enforcement risk. For businesses, proactive engagement with CPPA publications is not optional. It is a critical part of demonstrating good faith compliance. Guidance materials offer both roadmaps for compliance and insight into enforcement priorities. Compliance operating models must adapt to the reality of CPPA oversight. Businesses subject to California law must establish governance structures, data mapping, consumer rights workflows, and vendor management programs that can withstand regulatory scrutiny. This often requires cross-functional collaboration between legal, IT, marketing, and operations teams. Privacy programs must be documented, regularly audited, and aligned with CPPA expectations. For organizations, compliance is no longer about isolated policies, but about integrated systems that demonstrate accountability across all dimensions of data handling. State privacy enforcement thus reflects two complementary models: broad Attorney General authority under consumer protection laws and specialized oversight by the CPPA in California. Attorneys General bring flexibility, leveraging UDAP statutes to address a wide range of privacy harms. The CPPA introduces precision, creating detailed rules, conducting audits, and focusing specifically on data practices. Together, these authorities ensure that privacy is not only codified but actively enforced. For businesses, the message is clear: compliance must be comprehensive, proactive, and resilient, reflecting both the breadth of Attorney General powers and the specialized depth of CPPA administration. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.